Welcome to TCPA Audit. The narrator of this video is not an attorney, and nothing in this video is legal advice. This video only contains the musings and thoughts of a non-lawyer. The purpose of this video is for entertainment and to provoke thought. You should not assume anything you hear in this video is true. The narrator of this video's thoughts and opinions might well be wrong. If you find anything interesting in this video, you should research it yourself. In case you missed it the first time, the narrator of this video is not an attorney, and nothing in this video is legal advice. Please don't ask the narrator of the video for legal advice or to answer legal questions. Only lawyers can give legal advice, and the narrator is not a lawyer and can't comment on your situation. If you would like the narrator to comment on telemarketing-related public information, such as a court opinion, please email tcpaudit@proton.me with a link to the public record, and why you think that public record merits a closer look.
This is the first video in a three-part series looking at 3 lawsuits from a Ken Johansen. And I wanted to look at this series of 3 lawsuits because the first one starts out a little rough and the next 2 get worse. And so I wanted to look at each lawsuit and look at what went wrong. I have a few thoughts on things that could have been done differently and kind of look at the outcome. The first case I want to look at is Johansen versus Nat'l Gas Elec. And this opinion is based on a motion from Nat'l Gas Elec, a motion to compel arbitration. And at the start, this case, the court kind of signals that this is going to go rough for Mr. Johansen. NG&E contends that Johansen initiated a call to Nat'l Gas Elec and enrolled in their services. And that's not a great start for the court to be kind of taking Nat'l Gas Electric's side at the top of the case. Now, Mr. Johansen will go on to win the motion on arbitration. The court will rule that there wasn't a meeting of the minds on arbitration. But that's kind of the last good thing that happens to Mr. Johansen in this motion. And so kind of turning to this, the court now turns to a troubling issue that the parties' briefing on the motion to compel arbitration brought to light. The statements of Johansen in his affidavit and the representations of his legal counsel that this lawsuit is based on a ruse. And that's again something that you don't want to see in your court opinion. Johansen admits that he posed as an interested consumer when he received a telemarketing call from Nat'l Gas Elec on June 13, 2023. We all get telemarketing calls, and I don't know why we can't pose as interested consumers based on the circumstances, but I think where Mr. Johansen kind of turned this court against him is, number one, Johansen disputes Nat'l Gas Elec contention that he's the one that initiated what apparently is the first call. But he concedes that when the first call got disconnected, he called back in order to complete the enrollment process. And I think this paragraph is kind of where the court really turned against him in this lawsuit. So scrolling down, there's a debate as to who called who first. Well, if you're suing based on unwanted calls, I do think it needs to be uncontested as to who called who first, but that's just maybe my personal opinion. Obviously, I'm not a lawyer. That's not legal advice. But Mr. Johansen then apparently called back and signed up with service. And, looking at kind of the outcome of this case, I can imagine that if Nat'l Gas Elec had called him 10 times, and he had not posed as an interested consumer in those 10 calls. He had not called them back in those 10 calls. I'm pretty sure that this court case would have turned out very differently for Mr. Johansen. And in my opinion, that's kind of the lesson learned on this court case. I think Mr. Johansen should have waited for National Gas and Electric to either, just not call him again, in which case, Mr. Johansen, I'm fairly certain, didn't have a case here. Or, National Gas and Electric on their own volition, maybe they would have kept calling. And then maybe then if Mr. Johansen had posed as an interested consumer, this case would have turned out very differently. But we'll get back to this later. So National Gas and Electric calls him again on June 14th and then again on the 15th. And in both of these calls, Mr. Johansen doesn't come out and say, hey, I just played along long enough to find out who you are, please put me on your do not call list, why did you call me in the first time? Apparently he doesn't do that according to this court opinion, and but then he sues for these calls that happened after he acted like an interested consumer. And so the court kind of takes him to task here, saying, well, you called them, you set up services with them, then they called you later, and the court says, those are not telemarketing violations because, essentially you invited the calls. And scrolling down, the court keeps talking about how Mr. Johansen called them back. And so at the end of this court case, he loses. And this is kind of a theme that I see in the next two court cases is, I think this is a mistake that someone can make who's getting an unwanted phone call, and you're very annoyed by it, and you want to know who did it, and you want to hold them accountable. And if Mr. Johansen, I think, had maybe thought about this court case and learned the signals the court was sending, I think he would have fared better in his next two court cases. But his next two court cases kind of build on this and, in my opinion, get worse. And my underlying, my personal takeaway myself from this court opinion is, I probably wouldn't sue on just two unwanted phone calls even. If they call me once or twice, I don't think I'm going to call them and express interest and sign up for their services. Some judges are just not going to like you, and they're not going to like your claims. And to me, if a judge doesn't like you and you come to court with one or two calls, you're going to kind of open the door for the judge to rule against you. But if Mr. Johansen had come with 10 unwanted calls before he started investigating, if on calls 1 or 2 he said, I don't know why you're calling me, please put me on your do not call list, I think the judge in this case, either one, wouldn't have been biased against him, or two, maybe the judge would still been biased against him. I've seen this in my own life. I've had a couple of judges tell me, these are just phone calls. I don't care what the law says. I'm not giving you any damages for phone calls. But even if your judge has that private opinion, if you come with 10 phone calls and in the first couple of phone calls you said, I'm not interested in your services, please put me on your do not call list, would the judge have had the ability to rule against Mr. Johansen in the way that he did? And for myself, I tend to think that the judge would not or could not have written this opinion if those facts had been a little bit different.